A unanimous 9-0 Supreme Court decision just dropped, and it is already sending shockwaves through every police department, every courthouse, and every government agency in America. And if you are a gun owner, a driver, a homeowner, or simply someone who values their personal freedom, the next few minutes could be the most important minutes of your entire year. Because here is what nobody in the mainstream media is telling you right now. This ruling does not just tweak one small legal technicality. It does not just affect one state or one narrow group of people. This decision fundamentally rewrites how the Fourth Amendment and the Fifth Amendment protect you in your daily life. We are talking about your right to be free from unreasonable searches, your right to stay silent, your right to be treated as innocent before the government can touch your property, your home, or your freedom. Hit that subscribe button right now before we go any further, because this channel exists for one reason only: to make sure responsible, law-abiding Americans like you never get blindsided by a legal change that could turn your life upside down overnight. 90% of gun owners will never hear this explained clearly. Today you are going to be in the 10% that does. Now let us talk about what actually happened inside that courtroom. The Supreme Court of the United States just handed down one of the most consequential constitutional rulings in recent memory. 9 justices, 0 dissents. Not a single one of them disagreed. And in the world of constitutional law, that kind of unanimity is extraordinarily rare. When all 9 justices agree on something, the entire legal system is forced to pay attention immediately. The case at the center of this ruling forced the court to answer a question that lower courts have been fumbling badly with for decades. How much process does the government actually owe you before it can restrict your constitutional rights? How much evidence do they truly need? How fair does the hearing actually have to be before they can reach into your life and take something from you? For years, the answer depended entirely on which judge you stood before and which state you happened to live in. Some courts said a quick informal hearing was plenty. Some judges signed emergency orders in minutes based entirely on one person's unverified story. Other courts demanded a full, rigorous process with real evidence and real witnesses. The inconsistency was staggering. And for gun owners especially, that inconsistency was creating a legal minefield that nobody was warning you about. The Supreme Court just swept all of that confusion off the table with one clean, unanimous ruling. They said this: the Constitution means what it says. Due process is not a suggestion. It is not a box to check quickly before the government does whatever it wanted to do anyway. It is a genuine, meaningful guarantee that every American gets a real opportunity to be heard before their rights are stripped away. That single statement changes everything. Now, you might be wondering why this matters specifically to you as a gun owner. Let me paint you a picture that is happening to real people in real towns across America right now. You are a responsible gun owner. You have your concealed carry permit. Your firearms are legally purchased, properly stored, and carefully maintained. You have never been arrested. You have never threatened anyone. You are exactly the kind of citizen the Second Amendment was written to protect. But one morning you wake up, and a neighbor you had one argument with 3 months ago has filed an emergency protective order against you. Maybe it was a dispute about a fence line. Maybe it was a disagreement about noise. Maybe they just do not like the fact that you own guns and they saw an opportunity. Under the old system, here is what happened next. A local judge reviews that order in private, often in less time than it takes you to eat breakfast. They hear one side of the story. Your side is completely absent from that room. The order gets signed, and before you even know it exists, officers are showing up at your front door with a legal requirement for you to surrender your firearms immediately. No hearing, no evidence presented against you, no opportunity for you to speak a single word in your own defense. And if you did not hand over those firearms fast enough, you were suddenly facing a federal criminal charge. That was the reality for thousands of gun owners across this country, and most of them had no idea it could happen until it was already happening to them. This Supreme Court ruling just put a wall between you and that nightmare scenario. Most people think the Fifth Amendment only matters when someone is sitting in a courtroom refusing to testify at trial. That is one of the most dangerous legal misconceptions in America today. The Fifth Amendment protects you from the moment any government agent starts asking you questions with the intent of building a case. It protects you at a traffic stop. It protects you when investigators call your cell phone asking for a casual chat. It protects you when an officer knocks on your door at 7 in the morning and says he just needs 5 minutes of your time. What this unanimous ruling does is remind every court in the country that due process under the Fifth Amendment is not a formality. It is a fundamental right that demands real substance, real notice, real time to prepare, real opportunity to respond with evidence and witnesses of your own. The government cannot hand you a piece of paper on Monday and demand your firearms on Tuesday while your attorney is still on voicemail. The government cannot base a life-altering legal order on hearsay rumors or the one-sided emotional story of someone who carries a personal grudge against you. They need real evidence. They need a fair process, and you deserve a genuine chance to fight back before anything is taken from you. That is what 9 justices just unanimously confirmed. But here is the part that has legal experts genuinely alarmed right now, and it has nothing to do with protective orders or permit hearings. This ruling contains language buried deep inside the opinion that directly challenges how police have been conducting traffic stops, home visits, and consent searches for the past 20 years. And it brings us to 5 specific words that this ruling now makes more powerful than at any point in modern American history. 5 words that, spoken calmly and clearly at the right moment, can create a legal wall between you and a wrongful search or a wrongful seizure. Picture this scenario carefully because it is more common than most people realize. It is a Wednesday evening. You just finished a long shift. You are driving home on a road you have driven 1,000 times before. You are carrying your legally owned firearm in your center console exactly as your state law permits. Your concealed carry permit is current, your registration is current, your insurance is current, you are doing absolutely nothing wrong. Blue lights appear in your rearview mirror. Your heart rate jumps even though you have done nothing illegal. That involuntary reaction is completely normal. It happens to everyone. But what happens in the next 60 seconds can mean the difference between driving home safely and spending the next several months fighting a legal battle that drains your savings and threatens your gun rights permanently. The officer approaches your window. He asks for your license and registration. You provide them calmly and politely. Then comes the question that changes everything. Do you have any weapons in the vehicle? In that moment, the psychological pressure is enormous. You want to cooperate. You want to seem like the honest, law-abiding citizen that you genuinely are. Your instinct is to answer immediately and explain everything. The gun is legal, the permit is valid, you have nothing to hide, so why not just tell him everything and move on? Here's exactly why that instinct, though completely understandable, can work against you in ways you never anticipated. The moment you volunteer information beyond what is legally required, you open a conversation that has no guaranteed safe ending. A simple, well-intentioned explanation can lead to follow-up questions. Follow-up questions can lead to a request to search your vehicle. A request to search your vehicle, if you agree without a warrant, gives officers access to everything inside. And anything they find, even something completely unrelated to your firearm, can be used to build a case against you. So what do you do instead? You answer the required questions: license, registration, insurance, and when the conversation moves toward your personal property or requests to search you, deploy the 5 words that this Supreme Court ruling has now made more legally powerful than ever before. I do not consent, not aggressively, not confrontationally, calmly, clearly, politely, with direct eye contact and a steady voice. Officer, I do not consent to any search of my vehicle. That sentence does 3 things simultaneously. It asserts your Fourth Amendment rights on the legal record, it signals clearly that any subsequent search is not voluntary, and it creates the foundation for a suppression argument in court if the officer searches anyway and finds anything at all. Practice saying those 5 words out loud right now. Seriously, pause this video and say them. Because the time to practice is not when you are sitting in a car with blue lights flashing behind you. The time to practice is right now while you are safe and calm and thinking clearly. Now here is what happens if you clearly refuse consent and the officer searches your vehicle anyway. First, do not physically resist, ever, under any circumstances. Your safety matters more than winning a legal argument on the side of the road. Comply physically. But continue to state clearly and calmly that you do not consent to the search. Say it again. Make sure it is on the record. Because if an officer conducts a warrantless search of your vehicle after you have clearly refused consent and without legally established probable cause, any evidence discovered during that search can be challenged in court under the exclusionary rule. The exclusionary rule says that evidence obtained through an unconstitutional search cannot be used against you in a criminal proceeding. This ruling strengthens that argument significantly. Your attorney can use this unanimous decision to fight for suppression of improperly obtained evidence. Evidence that gets suppressed cannot convict you. That is the system working exactly as the founders designed it. We also need to talk about something that did not exist when the Fourth and Fifth Amendments were written, but now sits in your pocket every single moment of every single day. Your smartphone. Right now, your phone contains more intimate, sensitive, and legally consequential information about your daily life than your home, your car, and your filing cabinet combined. Your location history, your text messages, your search history, your photos, your emails, every gun-related website you have ever visited, every forum post you have ever made, every question you have ever searched about firearms, permits, laws, and modifications, all of it sitting in a device that fits in your shirt pocket. And here is the trap that is catching gun owners completely off guard right now. Many people believe that because their phone is password protected, law enforcement cannot access it without their permission. That belief is dangerously incomplete. With the right legal process, and sometimes without as much process as you would expect, your digital life can become evidence in a legal case against you. Think about your own phone for a moment. Have you ever texted a friend about a new firearm you purchased? Have you ever searched for information about modifications that are legal in your state but restricted in others? Have you ever discussed a conflict with a neighbor over text message? Every one of those digital footprints can be accessed, taken out of context, and presented as evidence in a way that makes a completely innocent gun owner look suspicious to a jury that does not understand firearms culture. Treat your smartphone as if it could be searched at any moment. Because in many legal circumstances it can be. Now we need to address something directly, because if you leave without understanding this one point, everything else loses half its value. The single biggest mistake that responsible, careful, law-abiding gun owners make is assuming their innocence protects them. That assumption is not just wrong. It is dangerously wrong, and it has cost real people their freedom, their firearms, and their financial stability. The legal system does not automatically know you are innocent. It does not see your clean record before it sees the accusation filed against you. It does not review your responsible gun ownership history before signing an emergency order at 8 o'clock on a Tuesday morning. The system responds to the process in front of it, and if the process in front of it has been triggered by someone with a grudge, a misunderstanding, or a deliberate lie, your innocence alone is not a shield. Your knowledge of your rights is your shield. Your preparation is your shield. Your attorney's phone number already saved in your contacts is your shield. The founders understood this. That is precisely why they built the Fourth and Fifth Amendments into the Constitution in the first place. Not because they expected every officer to be corrupt or every judge to be unfair, but because they understood that systems built by human beings are imperfect, and imperfect systems need structural guardrails that protect the individual from those inevitable imperfections. So here are the 3 concrete steps you need to take this week, not this month, not when you get around to it, this week. Start by conducting a full legal status audit on yourself. Check whether any protective orders, restraining orders, or extreme risk protection orders have been filed against you in your county or state court system. In many states, you can do this online through your county courthouse portal. This takes less than 30 minutes and the information is critically important. Then pull out every firearms-related document you own, your concealed carry permit, your purchase records, your registration documents where applicable. Verify that every single one is current, accurate, and renewed well ahead of its expiration date. Clean paperwork is invisible armor. Nobody notices it when everything is in order. But the moment something goes sideways, having every document current and accurate gives your attorney a much stronger foundation to work from. Next, sit down with every adult member of your household and have an honest, specific, detailed conversation about what to do if law enforcement comes to your door, not a general talk about being polite to police, a specific, practical, step-by-step conversation. Nobody opens the door without first asking through the closed door to see a warrant. Politeness does not require opening your home to an unannounced search. Nobody answers substantive questions about firearms ownership, storage, or any incident without an attorney present. Not your spouse, not your adult child, not the relative staying with you for the summer. Everyone who lives under your roof needs to understand that their well-intentioned answers to what seem like casual questions can create legal complications for the entire family. This conversation feels uncomfortable to have. Most families avoid it for exactly that reason. But discomfort in your living room is infinitely preferable to panic in your driveway when officers arrive unannounced and nobody in your household knows what to say or do. Finally, open your phone right now and save the contact information of a qualified firearms-friendly attorney who practices in your specific state, not someday, right now. Search for attorneys who specifically list Second Amendment defense or firearms law among their practice areas. Look for someone who has handled concealed carry permit cases, red flag, law challenges, or Fourth Amendment suppression motions. Make a phone call and ask a few questions before you need to make the call that actually matters. The gun owners who get through difficult legal situations with their rights and their finances intact are almost never the ones who knew more about the law than everyone else. They are the ones who had a qualified attorney involved early, every single time. Now here is the warning that most outlets are completely ignoring right now. The moment this 9-0 ruling was handed down, legislative teams in multiple state governments began working on responses. Not to comply more faithfully with the constitutional standard the court just established, but to find the edges of that standard, to identify exactly how close they can get to the line the Supreme Court just drew without technically crossing it. Several states with histories of aggressive gun regulation are already rewriting their red flag law procedures in ways that technically acknowledge the due process standard. This ruling demands while simultaneously constructing new procedural hurdles designed to make exercising your rights as complicated and time-consuming as possible. Other states are drafting new permit requirements, new storage mandates, and new reporting obligations, specifically calibrated to create administrative traps for gun owners who are not paying close attention. What is legal in your state today under your current permit may carry new obligations, new restrictions, or new reporting requirements before the end of 2026. The window between a law passing and gun owners learning about it is exactly where people accidentally fall into serious legal trouble without ever intending to break a single rule. Let us bring this home with the bigger picture because this ruling deserves to be understood in its full historical weight. 9 justices, not 5, not 6, 9. Every single one of them agreed that the Constitution demands more from the government before it can reach into your life and take something from you. Every justice currently sitting on the highest court in America, appointed by presidents from both parties spanning decades of different legal philosophies, looked at the same constitutional text and reached the same conclusion. Your rights are real. Your protections are real, and the government's obligation to respect them before acting against you is real and enforceable. That is a profound statement in the current political climate, and it is one that every gun owner in America should carry with them as both a source of confidence and a reminder of responsibility. Confidence because the highest court in the land just reminded the entire legal system that you matter, that your voice matters, that your property matters, that your family matters, that allegations alone are not enough to override the Constitution that every officer, every judge, and every legislator in this country is sworn to uphold, and responsibility because rights that are not understood cannot be defended, rights that are not exercised atrophy, rights that are not protected by an informed, prepared, and engaged citizenry are rights that exist only on paper. Everything shared here today is for educational and informational purposes only. This is not formal legal advice. Laws differ in every state and every situation has unique details. Always consult a qualified attorney who knows your local courts and your specific circumstances before making any decisions about your firearms or your rights. You watched this entire video. That already puts you ahead of the vast majority of gun owners in this country. Now take the next step. Subscribe and hit the notification bell because this legal fight is not over. It is just entering a new and more complicated phase. Drop a comment below telling me which part of this ruling concerns you most personally. The red flag implications, the traffic stop scenario, the digital privacy question. Your comment helps shape what gets covered next. And share this with one gun owner in your life who needs to hear it. Not to spread fear, but because informed neighbors make safer communities. And because the rights this ruling just strengthened belong to every responsible gun owner in America. Stay safe, know your rights, and never let pressure, panic, or ignorance cause you to surrender what the Constitution guarantees you.